going to move directly to the next panel of the future of dispute resolution. Well, at that point, I have the feeling that we are navigating in the shadows because we don't really know what are the case resolutions, what is the jurisprudence. So it depends on the different topics. And it's very interesting to see what we could have to bring some, I would say, some transparency and some efficiency in this field. So that's what we are going to discuss now. So yes, please, Pietro Ortolani, Leandro Toscano, and Federico Ast join me on the stage so that we can have the next panel on what's next, which dispute resolution mechanisms for the eSport industry. I have the feeling that it should be in a plural form, so which dispute resolution options, of course, because we are not going to have a one-size-fits-all, as Oscar just said. So I'm very happy to introduce our next speaker, Pietro Ortolani, who is a professor of digital conflict resolution at Radboud University in the Netherlands. In addition to his academic role, Pietro Ortolani is admitted to the bar in Italy and works as a practitioner, mainly in arbitration. And he has made significant contributions to the field of online dispute resolution, ODR, showcasing his deep interest in exploring the intersection of conflict resolution and technology. His research also delves into how courts and arbitral organizations are being transformed by technological developments. So we are very fortunate to have him share his insights with us today. Thank you, Pietro, for coming here. And we are going to hear you on the use of ODR for eSports disputes. The floor is yours.
Thank you so much. Well, first of all, Florence, thanks. It's a pleasure and an honor to be here with you. Thanks to WIPO, thanks to Kleros. My topic, my title, as you can see, is The Challenges of eSport Dispute Resolution Through the Prism of Online Dispute Resolution. And this word, challenge, suggests that I'm going to be critical. To a certain extent, that's true. Some people might say, as an academic, I'm paid to complain. My partner would argue that sometimes I bring my work home as well. But I don't want to mislead you. I think there's a window opportunity for online dispute resolution in the field of esports. And I will also try to show the potential of ODR in this field, of course, on top of showing the challenges that we are currently facing. Just to walk you through the agenda for my short presentation, I will start by introducing this broad and hotly debated notion, in fact, of online dispute resolution. And then I will walk you through the needs and specificities of esports and esport disputes, but I will do that very briefly because we have already heard about it from other speakers. And finally, in the core of my presentation, I will try to put the two things together, essentially wondering to what extent there is a potential of using ODR to resolve certain types of lists of esport disputes. Starting with the first point, what do we talk about when we talk about online dispute resolution? We talk actually about a lot of different things, and in fact we could maybe have an arbitration procedure to put academics together and make them agree on what they mean when they talk about online dispute resolution. Some people use this acronym ODR to talk about the public sector, in fact. So to talk about the digitalization of state justice, the fact that state justice increasingly uses digital tools, uses technology, uses different types of digital tools to support the working of public courts. That is one approach to ODR, is what some people call public sector ODR. It is something that the European Union has been engaging with, so far unsuccessfully, I must say, but it is one possible approach to ODR. The second approach to ODR is to use technology within the existing alternative dispute resolution procedures. So we have, and we've had for centuries, arbitration and mediation. And the question is there, to what extent can we use technology to improve, to enhance the efficiency of those procedures, to cut the costs of those procedures. This is something that we all dealt with to a certain extent, for example, during the COVID-19 pandemic, when we switched to online hearings, for example. So basically, injecting digital tools within already existing alternative dispute resolution procedures. But ODR means more than that. Technology also fosters the emergence of new, unprecedented forms of dispute resolution which did not exist in the offline world. So basically, you can just do more than just injecting technology into the old procedures. Technology can be used to actually devise entirely new procedures that did not exist before the digital era. Sometimes we talk about a fourth party. So technology actually being an additional player in the procedure, in the dispute resolution realm, essentially allowing us to do more and to do something different and to be more creative than simply having online arbitration or online mediation. I won't say so much about that because I think Federico will give us a prime example of how you can do that using, in particular, blockchain technology. Now, it's interesting because the field is new, but it's already full of tensions, full of disagreements, full of debates. And one of them is the underlying tension between due process and speed. That is, in and of itself, nothing unique to ODR. We know about it from emergency arbitration, for example, right? So you always need to strike some kind of balance between due process, the right to be heard, the right of the parties to present their case, the impartiality and independence of the adjudicator, and on the other hand, the need to get the job done. And as we have already heard in the field of e-commerce, to get the job done relatively quickly, very quickly, hopefully, right? So online dispute resolution sometimes, often I would say, entails a certain shift, which means, of course, not that we forget about due process, but that we try to give the parties due process in a radically different way, and to get the job done to find a resolution of the dispute in a matter of days or even hours instead of months or even years. That is an underlying tension in this debate about online dispute resolution. The second underlying tension that I want to highlight is that there are different players, different developers, for example, different vendors, different actors that try to make this idea of ODR come into actual practical fruition. And they're not the same. Some of them, I would say, are best understood as facilitators. So basically, they want to create tools that help us improve what we already have. So for example, tools for a better online case management in arbitration, tools for better online hearings. So they want to turbocharge existing procedures. But there's also other developers, other players in the field that are best understood as disruptors. And they say, well, the old train of justice is irreparably slow, ineffective, inadequate. I actually want to blow up the tracks. I want to create something radically new. And of course, these are interesting tensions for us because we are trying to build something new for eSports. And the question is, should we be facilitators or should we be disruptors? Of course, I'm simplifying. We could probably be a little bit of both, but it's interesting to have this in the back of our mind when we think about the resolution of eSport disputes. Now, some cases, some success stories for online dispute resolution. The most old and popular one is e-commerce. In the 90s, when e-commerce started, the players in the field, and of course at the time the biggest player was eBay, faced a very big problem. That is to say, how do we get people, consumers for example, and also traders, to trust us, to trust the system? And they quickly came to a realization. If you leave these people, traders and consumers, alone with their disputes, they will simply not use e-commerce because the complexities of courts, for example, but also of traditional arbitration, are overwhelming for small value disputes, and especially when the dispute is cross-border. And of course, e-commerce is meant to be a global phenomenon. So what they did very quickly is understanding that if they wanted this to work, and it did work, they needed to create their own dispute resolution system, their own online dispute resolution system. That's what they did. Interestingly, in the 90s, in fact, eBay employed public sector servants, and they hired them to say, build us a court, build us a dispute resolution procedure, because if we don't afford these people reliable and fast and cheap, actually free of charge dispute resolution, nobody will use the platform. Platform is, of course, an anachronism. They didn't call it that just then. Another success story concerns automated negotiation or blind bidding. So sometimes the parties want to engage in a sales and purchase transaction, but they don't agree on the price. Or they agree on liability, but they don't agree on quantum. Now, a way to get them to resolve the dispute is to bid, to make an offer to the other party without knowing what the other party would accept. And if the two offers come within a certain range, then you can find an agreement. Well, that is a traditional application of online dispute resolution because it's a pretty simple, actually automatable type of dispute resolution, and it's worked quite well through the years. But there's also more recent applications. For example, dispute resolution for smart contracts. Again, I'm not going to say so much because I think it's a prime use case for Kleros, of course. And also content moderation. Spoiler alert, if you're in the neighborhood, tomorrow we're going to have another conference on that topic. But it is also, of course, a prime use case for dispute resolution. For example, disputes concerning the demonetization of content. Dispute concerning online freedom of expression. Another use case I don't have on the slide, but I just mention it, is of course domain names. ICANN UDRP procedures. That is also very successful, and it's something that leverages technology to create a transnational procedure for the resolution of a particular type of dispute. So the question is, to what extent can we learn from that and use those experiences in the field of esports? Now, I'm not going to say so much about esports because I'm not an expert, cards on the table, but also because we have already learned about the specificities of the field. A couple of things I want to mention. There's a network and a galaxy of stakeholders we have learned today, and that makes it so that to a certain extent you can make parallels with traditional sports, but not always and not for every type of disputes. There are also new stakeholders that enter the arena, so to speak. For example, the developers, the publishers of the games, or the streaming platforms. So to a certain extent, there's a comparison with traditional sports, but there's also new stuff going in there. And we see that quite clearly when we look at the types of disputes that could arise. Some of them, as we have said, are also present in traditional sports. For example, doping cases, match-fixing cases, or good old traditional contractual disputes, for example, between gamers, players, and the teams, sponsorship disputes, and so on. But there are also other esports-specific disputes. And the example of, for example, abusing of bugs or glitches in the game is telling. In fact, I myself have been a victim of this. I play Street Fighter with my friends, and we still play it on the Super Nintendo. For the young people in the room, the Super Nintendo is a gaming console that was commercialized and sold when I was young, so shortly after the Second World War. And in that context, if you play on that platform, Street Fighter, there's a way of making it impossible for your opponent to move their character. That is not a bug, that's a feature of the game. But my friends contend that I'm cheating when I do that, and I never managed to get as an athlete, I never got the declaratory relief I needed because I lacked efficient online dispute resolution. Now, jokes aside, of course, there is a window opportunity for new dispute resolution in this field, considering the specificity that esport disputes often have. I will mention some opportunities and some challenges as open questions for all of us to discuss, to debate. The needs of eSports we already discussed and we are all familiar with. To a certain extent, they are common to different types of arbitrable disputes. It must be fast. It must be cost-effective. It must be flexible. It must ensure expertise of the adjudicators. We've learned, for example, that at the cast this is a problem. It must be confidential, but it also must give us legal certainty. It must lead to finality, to enforceability sometimes, right? So there's different needs that we need to cater for. And the question is, can we use the experience of ODR, that now it's basically 30 years of experience, to achieve some of these goals? In a certain way, sure, we can, because ODR is actually perfectly placed to cater to some of those needs. Some of these disputes are what I like to call native digital disputes. So the entire factual pattern of the dispute finds place in the digital space, and therefore it only makes sense to use digital tools to resolve it. Actually, it would be absolutely artificial to have offline dispute resolution for this type of cases. Also, it's a new industry, it's rapidly growing, so it needs to be adaptable somehow. And online dispute resolution allows for quick iteration. You can build stuff, you can build procedures with a degree of flexibility that is unprecedented in state courts, which we have learned are not probably the best forum for this, but also I would say in a traditional arbitration forum where it's more crystallized. You know, you can revise the arbitration rules, but it takes, of course, significant time to do so. It's difficult to do so. ODR traditionally is very fast. Actually, we have data on the preferences of traders on e-commerce platforms, and interestingly, speed is their best preferred feature about ODR. The average trader on Amazon or eBay prefers to lose the dispute on day 1 than win the dispute on day 14. That's quite understandable. You know, it's cost of business. They know they're going to need to reimburse a minority of unsatisfied customers. What they want to know is, do I need to do it? Tell me right now. Let me go on with my business. Let me not have any negative consequences in terms of rating, in terms of my visibility on the platform. I think it's similar here, you know. If you have an e-sport dispute, you need an answer in a matter of hours, hopefully. And you need scalability, right? So, of course, digital tools seem perfectly placed to deliver this type of goods, this type of needs must be addressed adequately, especially in a cross-border setting. And we have learned, indeed, it is something that we have heard throughout the entire afternoon, these disputes are almost always cross-border in nature, right? However, there are also some open questions. So rather than just giving you a sales pitch on online dispute resolution and on how to adapt those experiences to the specificities of esports, I also want to point to some elephants in the room. Again, not because I think those are insurmountable obstacles, but because by focusing on the difficult questions, we can make the next step, I think. The first question is, well, ODR has worked particularly well, but especially for predictable, high-volume, low-value disputes. Take e-commerce, for example. The average e-commerce dispute is very simple in nature. Somebody has not received the goods, or the goods are broken in transit, or they're just non-conforming, or the price has not been paid. They're very repetitive and they're very simple. The problem that ODR solved is the volume. There's an enormous volume of disputes. So ODR worked well because with this high frequency, high volume, low value disputes, arbitration was not viable. Courts were not viable, but what eBay or Amazon or PayPal build is. And my question is, are eSport disputes predictable and comparable to one another? Are they that type of dispute? Well, the answer is probably it depends. In some cases, they might have some kind of scale phenomenon, maybe if you look at the amateur sector, but the disputes we've heard about today are not. They're very complex, in fact, and they're unique. They leverage some fact specificity of a certain game, of a certain tournament, of a certain contractual relationship between a player and an athlete, between a developer and a federation, and so on and so forth. Second question I want to ask you is, well, ODR, up until now, has worked very well for disputes that do not require a detailed legal analysis. In and of itself, it's not hard to resolve the average e-commerce dispute, for example. You actually can do it on an almost instinctive basis without going into the specificities of international sales law, typically. But do eSports require specialistic expertise? I would say in many cases they do. Again, it depends. When I was learning about this problem of organizing competitions without the license of the developer, I thought, well, maybe that is actually a new market for friend arbitration. There might be a way of getting these developers to agree on a form of very simple arbitration to determine fair, reasonable, and non-discriminatory fees so that they cannot charge you $72 gazillion for League of Legends license to run your League of Legends tournament. That might be, in fact, almost a mathematical problem sometimes. But in other cases, I would say, it requires a detailed legal analysis. And because of the presence of the streamers and the publishers, that in fact is likely to come up with problems of mandatory law, even of public policy, to an unprecedented extent. Think of the arbitrability of competition law issues, in cases where maybe the publishers are engaging in anti-competitive behavior. So my feeling is we need to learn from the experience of e-commerce, but build of some kind of online dispute resolution mechanism that is able to valorize and give a central spotlight to the expertise of the adjudicators. These are complicated disputes that require specialistic expertise. Another challenge is that ODR typically is not binding. It's not a form of arbitration. It does not have any estoppel effects. It does not produce res judicata effects. So in theory, you could go back to court and have it all overturned. Typically, people don't do it because the value in dispute is so small that it doesn't make sense to do so. But here, I learned from Patrick and from other speakers, the prize pool for the upcoming, maybe, World Cup is 60 million. These are not small value in disputes. So you probably need some higher degree of finality here, because otherwise, if everything can be overturned by national courts, then you will find yourself in a puzzle of overlapping national jurisdictions, anti-suit injunctions, parallel court arbitration procedures, the mess that we sometimes live in as practitioners in other fields, and we probably don't want to replicate in this new field, in this new growing field. Finally, online dispute resolution has proved to work well when there is a transnational body of rules to apply. Think of the UDPR. That is an enormous success story for domain names because it bypasses the complexity of national trademark law. Think of e-commerce. Well, the platforms apply their own rules. They don't apply the fragmented national consumer law, sales law. Now, do we have harmonized standards to apply here? To a certain extent, I learned today, we don't. We have actually a lot of disagreement about what the substantive law of eSports should be. And it's difficult to build a reliable procedure if you don't have substantive law. It's possible, I think, but it is a challenge. I started with an anecdote of my childhood as a Super Nintendo player. Let me stop with another personal anecdote. So I come from a small tourist town in Italy. And it's full of small restaurants and small hotels that offer food. And when I was walking around the town, I noticed that the cheapest options often offer only two types of pasta. One of them is a sauce I recognized, that is, amatriciana, tomato, pesto, whatever. But the other one was always chef's sauce. What is the chef's sauce? So I asked a friend of mine who works in one of these restaurants, and I asked them, what is a chef's sauce? And he said, well, it's whatever sauce we cooked yesterday. We add some crème fraîche to it, and we call it a chef's sauce. Which is funny, it's light of hand. It's the illusion of choice when you don't actually have choice. But in practice, what we are doing here is we have a rich tradition of sports and a rich tradition of arbitration. And we are about to pour a very interesting digital crème fraîche over all of it. That's eSports. Let's use this chance together to do more than just putting old wine in new bottles. Thank you very much.
Well, thank you very much, Pietro, for this very interesting speech. So let's try to make a nice sauce. Yes. So the second speaker I'd like to welcome to this panel is Leandro Toscano, who is head of business development and digital content disputes at the Arbitration and Mediation Center of WIPO and co-organizer of this conference. Leandro Toscano will share with us the WIPO's experience in resolving disputes through ODR mechanisms. He will also discuss the potential application of WIPO's ODR mechanisms in the eSports sector, opening up new perspectives for effective conflict management in this rapidly growing industry. Thank you very much, Leandro, and you have the floor. Thank you.
Hello again. So now it's my time to talk about the experience of the World Intellectual Property Organization Arbitration and Mediation Center. So my idea is to share with you the different things that we do at the center in terms of policy, in terms of understanding the needs of users, experiences in other sectors, and to also, of course, focus on the esports and video games industry, to then leave some ideas, perhaps some thought-provoking ideas, so we can discuss later in our discussion. So you've heard about WIPO already quite a few times during today's conference. Now it's time for me to at least give you a few pointers on what WIPO is and what do we do, so you can better understand how WIPO could be helpful for this industry. WIPO is part of the United Nations, so it's a specialized agency, and it specializes in intellectual property. It has 193 member states, so we have a lot of countries from around the world that come to WIPO to work on different projects to, for example, negotiate treaties. Like in the past 2 weeks, we had delegations of about 1,200 people coming from around the world to negotiate a treaty, in this case, to a different topic. But it's a forum. It's a forum where we talk about policy, where we try to help developing countries to implement IP policies, to enhance their IP protection, but also, and this is what makes WIPO a little bit special compared to other UN agencies, we provide services. And these services aim at facilitating the protection of intellectual property, and that could be related to, for example, the registration of patents or trademarks. As you know, these IP rights are territorial, so if you want to register a trademark in France and in Spain, you have to go to both countries and go through different administrative procedures. But through WIPO, we offer systems, global systems, that help the IP ecosystem to expedite that and to have a one-stop shop to be able to make the most of your ideas and the most of your IP rights. Among the services, we started providing dispute resolution services, what we call ADR, or Alternative Dispute Resolution Services, alternative to the traditional core litigation system. And that happened quite a long time ago. That happened exactly 30 years ago. So we have seen the evolution of the IP ecosystem. We have seen new technologies. If we think about the mid-90s, we probably were not internet users yet, or early adopters could be using internet at that stage. So we have seen a lot of evolution in the digital environment, and that connects very well with the video games and esports industry. At the Arbitration and Mediation Center, we don't resolve ourselves the cases, so we are not the arbitrators, the mediators, but we have a long list of experts, more than 2,000, coming from all regions that specialize in different areas. Trademark lawyers, for example, or engineers, or technical expert that can be appointed to resolve specific matters related to IP valuation. So we have this group of people that have the substantive knowledge, but also know about dispute resolution. And for that, we conduct training. We help them to better understand the advantages that ADR can offer to resolve disputes in the IP environment. The users of the services come also from different industries. And nowadays, we can say that more than 50% of the parties in cases are SMEs or inventors or creators, like the smaller players in the IP ecosystem. We have a large participation also of multinational companies, which were the traditional users of arbitration. So at the beginning, we would see parties coming from industrialized countries, cases of very high value related to, for example, pharma patents, biotechnology, mechanical engineering, etc. And nowadays, we see lots of disputes that are more of a, let's say, low value and high volume, as Pietro was just explaining. The services that we provide are basically mediation, arbitration, expedited arbitration, we'll talk about that, expert determination, another option that can be very much applicable to this industry, and the main name dispute resolution, as also Pietro was mentioning, about the UDRP. I talk a little bit about what we do, that we provide assistance to parties, so we're constantly in contact with the different stakeholders of the IP ecosystem. So we often receive queries coming from, for example, video game developer or mobile application developers that are interested in knowing, well, I have a contract, I want to include a clause, I don't want to go to the courts, how can I do? And we provide all that kind of assistance, so that's part of our mandate also. Of course, we cannot provide any legal advice and we cannot represent any party in a dispute, but we can always try to help parties to get closer. That's what we call good offices or bons offices in French, which is basically bringing parties together to explain how mediation and arbitration works. Many times we observe that the parties don't know about mediation or arbitration, or they confuse them. And as we all know by now, the type of procedure that you choose is very much in line with your strategy. If you want to keep a business relationship with a business partner, well, then mediation perhaps is a better option. You have a forum where you can renegotiate an agreement, for example. We see that happening a lot in the licensing agreements, where maybe you need to agree on new terms. Or if you want to, for example, terminate a contract because the other party has not been in compliance with the obligations in the contract, then arbitration might be a better solution, because there you will have a final and binding decision that cannot be appealed in principle, and that is enforceable through the New York Convention. So choosing one or the other, or many other options that we have too, like expert determination, will very much depend on your strategy and what you're looking for. Now, if you have a quick look at this dashboard here, these are statistics of WIPO cases that are, of course, related to all kinds of IP, so we're not just focusing on video games. We don't have that many cases in this area yet. But here what we can see is that the different areas, like trademarks, copyright, and digital content patents, are quite similar in terms of the volume. We have noticed a sharp increase in the digital content disputes area and copyright, and this is also very much linked to the activity that's happening in the digital environment. And these disputes are also of an international nature in most of the cases. In about, or more than 70% of the cases, we observe that either the parties are located in different jurisdictions or the IP rights are protected in multiple jurisdictions. So for that, we need to have dispute resolution systems that can accommodate it. If we go to the courts, then the enforceability of a decision coming from a court in another country will be quite difficult or impossible in some cases, while if we use mechanisms like arbitration, we can benefit from the New York Convention mechanism. So these are some very quick pointers. We can also observe the settlement rates in both mediation and arbitration. And in mediation, of course, the objective is to reach an agreement with the other party. And there we see that every time a mediator is appointed in a case, there is a 70% chance for the parties to reach an agreement. So that's a very high percentage. Of course, in some situations, a party might propose mediation to the other party might not accept. This is a voluntary and consensual procedure, so we cannot force anyone to be part of that. And the nature of mediation is to have parties trust in the mediator and trust in this neutral environment to negotiate and try to reach what's called a win-win solution, where everybody can commit to an agreement. In arbitration, the main objective of arbitration is not typically reaching an agreement, it's obtaining a decision. But what we observe here is that the parties, after going through a whole arbitration procedure, many times right after the arbitrator issues the award, maybe after a year of work, they realize perhaps it's better to reach an agreement instead of getting a decision that says that this contract is not valid or that the other party needs to pay or I have to pay damages, for example. This happens also in situations where we have what we call escalation clauses. So escalation clauses are combined clauses where you first try to resolve the dispute through mediation, and then if you don't manage, you can pass to arbitration. And these clauses are present in over 40% of the contracts that are referred to WIPO for resolution. So having mediation as a first phase, can save you from having to go to a full-blown arbitration. And in some cases also it can help you to narrow the dispute down, because sometimes there are misunderstandings and you go to the arbitration with a long list of items for the arbitration to decide. Of course, in arbitration, time is money because you're paying an arbitrator normally by the hour, so the cost of the proceedings can be quite high. And the complexity, so you will need arbitrators that are specialized in the subject matter, but you also need your counsel to be specialized in arbitration. The whole procedural aspect of arbitration can be quite tricky, so you need that expertise. So this is all to say that mediation as a first phase is, at least in WIPO's experience, has shown a lot of benefits. And basically, you can include a period of time, so you can say, let's try mediation for 60 days, and day 61, any party automatically, due to the text of the clause, can move on to an arbitration. WIPO then offers rules for mediation, arbitration. So these rules are basically, let's say, they will cover the whole procedure from how to file the case. It will explain which documents you need to attach to your request. They will also explain how to appoint the arbitrators and mediators, all the rules about impartiality, independence, availability, how to replace a tribunal whenever there's an issue, which kind of evidence can be presented, how the arbitration tribunal will then judge the evidence or decide which evidence is the one to consider. It will also explain, in the case of arbitration, all the formalities that the arbitrator needs to comply with when issuing an award. So it has to be in writing, you have to have, all the explanation of the facts. So all these things are very important to then avoid any action to nullify, to get your arbitration award annulled, for example. The rules are very flexible, so if you agree with the other party that instead of having 20, 30 days to reply to a document, then you want to make it more expedited and do like 5 days, that's totally doable, as long as the parties agree to reduce that or to extend the different timelines. They're also very much in line with the New York Convention and with the Singapore Convention, so there's a quite new Oscar mentioned it before, this convention that was signed in Singapore, and it's about mediation. The objective of this convention is to make it easier to enforce mediation agreements. So let's say we go to a mediation, you reach an agreement with the other party, you sign a contract with the other party does not comply. Nowadays you have to go to the court, and the court will have to review all the merits, and you will probably need to go through a long procedure to be able to execute that. With the Singapore Convention, when the parties reach an agreement, in parties that are members to this convention, then that agreement will have, let's say, the force of an arbitration award, to put it in very simple terms, and you'll be able to execute that in a more time and cost efficient manner. How do you get to use, in the case of WIPO or any other arbitration procedure, arbitration or mediation procedure? So the typical way would be to include a clause in your contract. So you agree in advance with the other party that if we face any dispute in the future, we go to WIPO instead of going to the courts. That was a traditional way of referring cases to arbitration and mediation. The trend that we observe nowadays is to have either what we call a submission agreement, and a submission agreement is still an agreement between the parties, but that is reached by the parties after the dispute happens. So let's say that you realize that someone is streaming a video games or eSports competition and they didn't have any license for that. But perhaps you're interested because you're reaching out to a very large market. So it's not only a question of just like, banning them from streaming the competition, but perhaps you want to also benefit from that. So there's an opportunity for business. So there you can enter into an agreement with the other party to, for example, explore in a course of a mediation to reach this win-win solution and try to, for example, negotiate a license. So we see more and more of these cases that are arriving at WIPO through what we call the unilateral request. So the unilateral request is an invitation to another party to consider, in this case, mediation. In many cases, the other party is not interested. So if you are inviting, for example, someone that is a pirate that is copying your software, or someone that is selling counterfeit products, perhaps they will never reply, or they will say, okay, take me to the court and spend time and money. But in other situations, we can see that there's, you're showing your goodwill to resolve the dispute. In some jurisdictions, we also have already legislation, and procedural legislation, that indicates that if you didn't accept to participate in a mediation, then you go to the courts, you lose the case in the courts, maybe the judge can also impose fines on you for not at least trying mediation. So these are trends that we observe in different continents and in different legislations. So the unilateral request has been a very useful tool because in many cases the parties, they don't even need to appoint the mediator. The sole fact that they receive an invitation, in this case in a framework of a WIPO mediation, then triggers a possibility for parties to establish some dialogue and try to reach some agreement. Why ADR? I think we've been talking about this quite a lot throughout the day, but it's just to highlight, and for that I'm going to show you some results of a quite recent survey that we conducted at WIPO in collaboration with the University of Oxford and supported by the Ministry of Culture of the Republic of Korea. And this survey focused on disputes happening in the digital environment. So you could be talking about images, videos, audiovisual content, video games, mobile applications, and quite a lot of other issues. What we extracted for today's conference are some of the graphs that are more related to esports and to video games. And here we can see when we ask the parties a geographical spread of disputes. And in this case, we had a lot of respondents coming from Europe. So we can see that Europe was ranking quite high. And Asia is another area where we saw a lot of activity related to video games disputes. Then the amount of disputes, we had different ranges, and the one that was the highest for video games was the one between 10 and 100,000 US dollars in this case. So as we can see, of course, there are other smaller values like 0 to 10,000 that were also ranking quite high. So we can see that disputes in general tend to be not so large. When we also asked parties about the use of dispute resolution mechanism to resolve these disputes, they indicated core litigation as the most common way to resolve disputes for both contractual and non-contractual disputes. But then we saw that mediation and conciliation ranking quite high, so that's very encouraging because that means that already, at least in the experience of these over 1,000 respondents that took the survey, mediation and conciliation are in the radar and it's been used. Arbitration a little bit less, of course more for contractual than for non-contractual, because to agree with the other party to go to an arbitration, the stakes are always higher. So normally you would do it in the context of a contract. And then it's also interesting to see expert determination and arbitration under expedited rules. So WIPO offers this expedited arbitration, which is basically a condensed version of a standard arbitration where the timelines are shorter, the cost is lower. You can only appoint one arbitrator. In a standard arbitration, you could have one or three. Of course, if you have three, then the procedures are more expensive and they take more time. So we see this, the arbitration under expedited rules, being used a lot in the IT industry. And that includes the software development and mobile applications development. Then the expert determination, and here I'm going to connect to this with the domain name expertise that WIPO has developed throughout the years. Expert determination, let's say that it could be compared to arbitration in many ways, but at the same time, it doesn't have the effects of arbitration. So first of all, you will have here an expert that normally is a technical expert that will decide on a specific matter. It will decide whatever the parties requested the expert to decide. In the case of domain names, you will have only two types of remedies. You cannot recover your domain name or you can't. So that's all you get. You're not talking about damages, so it's a very specific and narrow procedure. You have a set criteria. If you meet the criteria, you get the domain name back. If you cannot meet the criteria, you don't get it. If you want to claim damages or if you want to go beyond, you need to go to the courts. So that's another difference with arbitration. Once you choose to go to arbitration, then you cannot go to the courts because it forecloses the court option. While expert determination, we allow you to go before, during, or after the procedures to claim different things. So you have the option. You have access to justice. You're not being banned from doing that. Expert determination is being used, for example, in cases of IP valuation. When you have two companies that, for example, a company that's buying another one, and this other company, the second company, owns IP rights, and it's okay, this is the value of my IP. The other company says, no, that's not the value. Okay, let's appoint an expert, and this expert can decide, and we accept whatever the expert decides. Normally, what we see is at a high rate of acceptance, right? So it's a consensual, voluntary process. So the parties, once they agree to appoint an expert, then they normally comply. And that happens also in the case of mediation. There's a very high rate of compliance with the mediation agreement because it's all set in an environment where the parties work with the trust of the mediator. So that's something to keep in mind, I think, for this industry, where you have players in the sense of not video game players, but the actors of the ecosystem many times will meet again, especially the bigger players, the bigger actors, and may want to collaborate. So this environment with mediation, expert determination can help to maybe reduce the impact of a decision from a court or even from an arbitrator. Then expert determination, the result could be appealed before the court, so you still have the possibility of getting it revoked. I understand that sometimes we need certain level of finality, and that's what Pietro was also claiming for. So again, it's a matter of strategy, of what you want, what's the outcome, what are your needs, and based on that, you can tailor the procedures. I'll give you an example of expert determination that can be quite useful to put it in parallel with an eSport competition. So at WIPO, we work with Palexpo. For those of you that are from the region, you know Palexpo is this convention center in Geneva that has different expositions. And one of perhaps the most famous one is the Salon de l'Auto, the car show that happens every year in Geneva. And there you have a lot of different brands having stands, and they are presenting new products, or they are, presenting new models or accessories for cars, etc., etc. To be able to participate in this environment, you need to enter into an agreement with the organizer of the exhibition. So we work together with Palexpo to develop what we call a fast-track procedure, which is an expert determination option, because it happens that there are disputes related to IP rights mainly designs, trademarks, copyright, no patents, because patents, to resolve a patent case, you know, in a very quick way, it could be, of course, very tricky. So, for example, you have someone that is presenting some accessory for a car, and maybe is naming the brand of another car manufacturer without any authorization, or presenting the logo, and the other party doesn't want that to happen. So in the past, you would have to go to the courts in Geneva, file for an injunction, get the police to go, and to take the product out of this exhibition. So that was not really a very nice way to do things. So we developed this fast-track procedure, and there, in 24 hours, an expert has to decide on this matter. There are model complaint, model response. There's a group of experts that are on standby for the duration of the exhibition. They are appointed even during the weekends, because normally the exhibition lasts for 2 weeks. And normally what happens is once you receive a case, the other party wants to settle, because so it doesn't even take 24 hours. So there's an incentive to settle, because then the fees are lower. So you say, okay, no problem, I'll take this product out. And then that's it, no hard feelings, and everything continues normally. So this could be, you know, compared to, if you want, to an eSport competition, where all the participants, they accept the terms and conditions. In the terms and conditions, you have this procedure, so you are already giving your consent to be part of this process. And that's what happens with the domain name. So every time you register a domain name, there are terms and conditions that, of course, we never read, but there's a clause there that says, I accept to participate in a UDRP procedure if there's any issue against this domain name. So then you cannot escape. You say, yes, I'm participating, and that's enough. You don't need to have, you know, like a certified copy by a notary or anything like that. So this is related to the consent, and it's some ideas that I think we can explore. There's also a link to the dispute resolution board. That's a procedure that we are using in other sectors, where what you have is a group of experts that are on standby for the duration of a contract, for example. So if there's any issue, then the parties automatically go to the dispute resolution board, and they will accept whatever the dispute resolution board decides. This happens, or it's a procedure that is very much used in the construction industry, also in the software development industry. If you're building a flat, it's 10 floors, you're in floor 5, you have a dispute, well, you want to finish the flat. Perhaps you don't want to get rid of the other party to start again with a new one. In research and development, also, you see this being used. So this could be another option for eSport, and it's something that we have already tailored and drafted, so we have it ready for that. To conclude, well, we have information available on our website, so you can find out about everything that we're doing in this area. Some of the cases, I'll leave it to you to have a look at the type of issues that we're seeing. We haven't seen many cases related to the industry yet, but we're getting a lot of consultations. So someone saying, I think that someone is infringing my copyright, so I need to see how I can solve it. With this, I'm just concluding mentioning again this collaboration with ISIC. I just wanted to say here you can see a LinkedIn post from our Director General, Darren Tang, so he's fully supportive of the idea of building something for the esports industry, and that's very encouraging because WIPO is working in many ways. As we're speaking today, there's an internet governance forum happening at the International Telecommunications Union, and WIPO is having a session there. One of our colleagues is presenting our work in ADR there, while other colleagues are talking about economics of video games or the protection of IP in this industry. With this, I think I'm concluding. I probably exceeded a bit of my time, but I thought it would be useful for you to give you an idea of the different things that we're doing at WIPO. I'm very happy to answer any questions afterwards, and I'll leave the floor for Fede now.
Well, thank you very much, Leandro, for this very interesting presentation of the experience of WIPO, the field of ODR, and its potential use for esports disputes. So it is with great pleasure that I introduce our next speaker, Federico Ast, who is a specialist in ODR using blockchain technology. The blockchain-based dispute resolution mechanism developed by his company Kleros uniquely offers solutions to disputes by using the wisdom of the crowd, game theory, and economic incentive mechanisms. I think that maybe you are going to speak about it. And Federico will share insights into how these innovative approaches, which transform the landscape of dispute resolution, could be applied to resolve eSports disputes. And Federico, as you know, is also co-organizer of this event. And for those who are not quite familiar with the term of decentralized justice, which is a special term, it simply refers to dispute resolution methods using blockchain technology. So that's why we say decentralized justice. I personally use BDR for blockchain-based dispute resolution mechanisms, but it's the same. So thank you, Federico, and you have the floor. Thank you.
Thank you very much. There's a presentation. I also had a Super Nintendo, you know, and I even had a Nintendo One, which is what we use for fun in the hard days of the Great Depression, basically. So I mean, most of you don't even know what a Nintendo is. Okay, so what game is this? I mean, I'm sure some of you know this. I know one guy there knows what games is this. So I'm going to tell you a bit about the story of Kleros. So this is Counter-Strike, of course, and I used to play, but not much, but I had a friend who was like a very big fan of Counter-Strike, and he played tournaments and everything. And one time he told me about how they solve disputes, about especially cheating in the Counter-Strike. And they had this system called Overwatch that they used, it was a panel of people, of other players. So when a dispute happened, it was sent to this panel of other gamers, and they would see the case. They see the video of the play, and then they would decide on who was right, Team A or Team B or whatever. And then, and this is what you see like as the interface of what it was like. And so my friend Reno introduced me to this, and I was in that moment starting to explore innovation in dispute resolution, and so it clicked to me because it was like the first use of crowdsourcing, right, for solving disputes in a game. But there was a problem with this. So this was great for crowdsourcing, but you didn't have really transparency, because how do you decide which cases to send? How do you decide what players are going to be picked as jurors? How do you decide how to count the votes on who? So this was basically done by a company in a black box, and so this didn't have lots of transparency. So my exploration took me into this direction. Okay, what if you combine this method of the Overwatch for dispute resolution in this cheating system? What if you put the transparency of blockchain for traceability of how decisions are made? What if you also add incentives, economic incentives, to make it more efficient? And this is more or less, how the main ideas that at some point became Kleros. And I know many of you might not know what this is, so I'm going to just explain very quick what Kleros is and how it works. So the typical example we mention is, a case that happens always in the new economy. Alice, she's a an entrepreneur from France, and she wants to make a video for her company, and she hires Bob, who is in Guatemala, to make a video, a 2-minute promotional video. And let's say that there is a dispute because she claims that Bob didn't make the job that she expected. And, what is she going to do? She's going to go to court in Guatemala to find a lawyer for like a $1,000 or euro case, or is she going to go to the ICC to solve? Of course, she's not going to go to arbitration in these big places, because that wouldn't even cover the cost of the taxi from the airport to the hotel. So Kleros can provide a solution for this type of cases. So imagine when they make the agreement, she sends the money into a smart contract, and this smart contract works as an escrow. And they both agree to have Kleros as an arbitrator in case a dispute happens. If there is no dispute, all is good. So she gets the video, he gets the money, everyone is happy. But if there is a dispute, this money stays locked there as an escrow, and then the case is sent to Kleros for arbitration. Kleros is a decentralized organization that's going to, it's built on blockchain. It's going to pick a number of jurors who are going to adjudicate the case. Why is it important that Kleros is built on blockchain? Well, because this brings the transparency that we didn't have in the Overwatch system. So now we know that evidence is not being tampered with because it's audited in the blockchain. Now we know that jurors are being picked in a fair way. I mean, everyone can check that in the code. And now we know that votes are being counted correctly. So both parties can trust that the system is going to work exactly as it was intended to work, because this is open source. Everyone can check. Jurors make a decision, and in this case, let's say the majority votes for Alice, so the money that was in this escrow gets sent to her, and that's how the case ends, okay? This is more or less how the system works. One key question, how do you pick jurors, right? And one important thing about Kleros is that you don't ask jurors to sign up for being jurors. You just ask them to have a token. So this, let's say this woman is a video producer from, I don't know, Vietnam, and she has a job in a video producing company, and during the day and the night, to make some money, she can be a juror in Kleros cases. So to be a juror, as I said, you just need to buy this token called Pinakion. The name comes from the ancient Athenian, ID you needed to be a juror in the cases happening in the popular trials in Athens. So it's a token based on Ethereum. Then, if you want to be a juror, you have to deposit the token into one of the Kleros courts. Kleros has many different courts addressing different types of disputes. So in this case, the token would be deposited into the court of videos. So she makes the deposit. Other people also make the deposit into that court, and Kleros selects randomly a bunch of jurors from those who deposited the token. So the token is like a lottery ticket that gives you the right to be drawn as a juror in the courts, in the court where you make your stake. And these people who are chosen will see the evidence and make a decision on the case, okay? And the most innovative thing about Kleros is, how do you make sure that these anonymous people from the internet, they don't just vote randomly or they don't get bribed and lots of things like that? How do you make sure that they know what they're voting about? And the innovation that Kleros brings is game theory. So this gentleman you see on screen is Thomas Schelling, Nobel in Economics, 2005. And Schelling is famous for different things, but in particular for one concept that is it's called Schelling point or focal points. He called them focal points, and we call them Schelling points in his honor. It's about how people coordinate to make a decision in situations where they don't know how the other will decide, but they have an incentive to reach a consensus. So if you are in Paris and you miss your friend because you missed each other, and then you don't have battery in your phone, typically people would go to meet where? The Eiffel Tower, right? I guess. So that's kind of the Schelling point in Paris. So you can use this system of incentives in the case of eSports. And I'm going to tell you a bit about some idea of an article we wrote back in 2018 with a colleague. Well, you know VAR, right, for football decisions. What if you could crowdsource the VAR into the crowd? So because imagine that you have to decide, you have this game, and then there is this play, and okay, watch this play, what happened. Some of you may recognize this game, but have you watched the play? What happened? Everyone saw it? Okay, so imagine you are a juror in this crowd VAR system, and then you have to make a decision, and then you have this interface, and okay, you have to decide what happened in this play. No penalty. No, that is a biased decision. You have to think, actually, imagine that 500 people were drawn as jurors to resolve this case, and you have to try to vote like coherently with those 500 jurors. If you vote coherently with the 500 jurors, you get a reward. If you vote incoherently with them, you lose money. I mean, I guess, what would you choose in this case? Well, who would choose no foul? Who would choose foul and yellow card? Okay, who would choose foul and red card? It's kind of it's on the fence here. In this case, what happened? Do you remember what happened? Yeah, it was
It was foul, penalty, red card, goal, out of the cup.
I think it was yellow card, and since it has a previous yellow card, it ended up in red.
Yellow, second yellow.
Yeah, second yellow. But so this is the idea of how jurors would make decisions in a case happening in this crowd bar system. And I use this to make the example because I know not every one of you knows all the rules of e-games. But this system can be, and we will see how, be applied to esports. Why Kleros uses this very different and special resolution mechanism? Because it's very effective, way more effective if you do online arbitration or online resolution in a traditional way. Of course, it's more efficient than having to go to, to a place to have a hearing, but it's a bit more efficient. Kleros, with this very different mechanism, can be like 10x more efficient, 10x faster, and has a transparency of blockchain. Okay? So this can be used to solve very low-value disputes, which are the kind of disputes that we want to resolve in the world of esports. Kleros is being used currently in e-commerce, insurance disputes, kind of also small claim courts, small claim company against user because of electricity, telephone companies. And let's see a bit about how we can use this in esports. And we will just see one example in an esports tournament, and we will see how everything we do at Kleros is always based on economic incentives. So there is a tournament of esports, and all of the teams that will participate, they have to make a deposit in order to sign up to the tournament, and that deposit stays held by the tournament organizers. Now there is a game between Team 1 and Team 2, and the guys who are at the border are the audience who are watching the game on Twitch, okay? So at some point, some amount of people of the audience, they think that Team 2 is cheating. So they are watching the game, and they say, they press a button, say, oh, Team 2 is cheating, and they make a little report, and then they make a deposit backing up their cheating report. So Kleros, in the future, we expect, will have different courts addressing different types of esports. Some of them will be for Age of Empires, others will be for Counter-Strike, others for FIFA. So the dispute is going to go, in this case, it's a Counter-Strike game, so tournament, so the dispute is going to go to the Counter-Strike court. And in the Counter-Strike court, a panel of jurors is going to be drawn, as I mentioned with that method I already discussed. These guys are going to adjudicate the dispute between Team 2, who is the defender, and the challengers, who are like prosecutors, right? And who have made the report of Team 2 cheating. These jurors are going to see the video of the game and see, the report was made because they say that this player is using an aimbot, which is a tool that helps you aim in the game. So they will see the video, everyone see, and they will make a decision on whether, yes or no, Team 2 is using this aimbot. And to make that decision, they will follow a set of guidelines that are typically used to make this decision about how the player is moving in the field, how the player is behaving, because maybe he's great at aiming, but then he has no idea what he's doing, where he positions. So there's a bunch of things that, evidence that one can use to see if there is a cheating going on. So based on these guidelines, the jury is going to make a decision. In this case, let's say the challengers win. So what happens? Team 2 is eliminated from the tournament because of cheating, and the deposit they made for participating, they lose that, and this gets sent to the challengers that participated in challenging the team, okay? Because they won the case, so they keep the team money. This is a fully decentralized system where the community decides what cases are sent to dispute resolution, and the community also will make the decision. So, and this is how I imagine decentralized justice being applied into the world of esports. It's just an example. There are different mechanism designs that could be used. So why do we want decentralized justice in gaming and esports? Well, because, as I mentioned, a similar mechanism like Overwatch was already implemented in the past, which was a bit similar, even if it didn't have the advantage of blockchains and transparency, because that's what we bring with decentralized justice, the idea of blockchain auditability, and this mechanism makes it very optimized for speed and efficiency, which is exactly what we need to resolve lots of disputes that need to be resolved immediately, so they don't stop the tournament from moving forward, okay? We cannot wait like 3 months until the dispute is resolved. So this is why these methods are going to be very important in what is coming for dispute resolution in esports. So thank you very much, and well, happy to take questions if you want.
Well, thank you very much, Federico. So it was quite clear. So we are going to come to the final discussion. So I invited Geoffrey Bruno and Patrick Piton to come on the stage. I think we are going to need some more chairs. In the meantime, you can already prepare some questions if you want to ask questions to our speakers. I'm going to give you my chair. So this is the one. Perfect. So welcome back. So are you ready for the questions? I have one first question to Patrick Piton, because you are just coming back. So what do you think about Kleros that has just been presented? I don't know if you knew already this BDR or this kind of dispute resolution mechanism, but what do you think you know very well the esports industry, so do you think that it would be a good mechanism? Would it be adopted by the community? It brings speed, it comes with efficiency, low costs, but there is a gambling aspect, and people do not rule on the basis of legal rules, but on the basis of what the things that the other people are going to rule. So what do you think of that?
So before answering this question, I will have one question for you just to understand correctly and perfectly the system. My only question would be, how do you ensure that there is no conflict of interest when the jurors are selected? Because one issue I would see is you are the spectator, you are for team 2 or team whatever, just like for the VAR video we saw, if I'm for one team, I would definitely say, oh, it's penalty, red card, whatever you want, and if I'm for the other team. Yeah. And if in the end the jurors that are selected are not independent, I'm not sure of whether the decision would be correct, if we can say correct.
That's a very good question. Of course, in this presentation, I didn't have time to go in deep into the mechanics because it would have taken too long. There is like an appeal system. So there is, in principle, anyone can be a juror. They are anonymous, so no one can check that you are not one of the parties. Okay, but so you can start the case with 3 jurors. And then if one of the parties, let's say the losing party, thinks there was like some conflict of interest and they lost unfairly because the court was attacked, they can appeal. There's going to be now twice as many jurors plus 1. So you go from 3 to 7. And then if there is also another, suspicion that there was a, kind of another attack because they had 4 of the 7 jurors in their pocket. They can appeal again to 15, and 31, 63, all the way to 511. So it's very hard to keep attacking even if you are like, and then as you get drawing more jurors, it's harder for the attacker, who is one of the parties in hiding, to keep having the majority, because you draw. It's harder to have to keep being selected and bribing more than 200 people, let's say, right? So this is a very sophisticated game theory system. There are lots of videos of me explaining exactly how this works. I don't want to go into details, but all of this appeal system makes it that even in the situation where there is no possibility to check that there is no actually a conflict of interest, still the system produces the right results, okay? And you have to, also check this and understand this in the context of the type of cases that Kleros is resolving. This is not going to be used for traditional, in a court for criminal cases, but in the context of a need of having fast systems of resolution. So that's where it makes sense, because it's very cheap, very fast. Okay.
So now we are going to have the lawyer answer.
Yeah. No, to answer that question, maybe it's more of a personal opinion, but sometimes I'm not convinced that the majority has the correct decision, but it's my personal opinion. And some cases I saw, even from some cases or sports cases before the case, you know that the case requires a tough decision sometimes. And if you need the gut to say that this is wrong or this is right, and I'm not sure that juror or people who are not maybe that specialized or anonymous people will always have the right decision and issue then a correct decision. But that's a personal opinion.
But there is an answer to this. When you use this system, at the end, what you create is the jurors are rewarded not because they are coherent with the other 2 guys in the round. They are rewarded based on their coherence with the last round that could potentially decide on the issue after a number of appeals that takes it to the Supreme Court, if you want, right? So if you are a juror in the first round, you need to think, what would the community of jurors of this community of practice of Counter-Strike gamers or whatever game think about this case, right? So it makes jurors try to empathize with the full community and try to think what they would decide in that case. So if there is a bias in the whole community about something, that would bias, Kleros jurors as well. But that's also kind of the same that happens in traditional systems. There is a society-level bias. Jurors or judges that participate in that society will probably have that bias.
So, thank you.
I always get this type of question, yeah.
Yes, it was. So, Pietro Ortolani, as a law professor, do you think that Kleros meets the requirements of fair justice? And what do you think? Would it be more important to have a fair decision or speed and low-cost decision that gives a solution to the dispute?
Also a very difficult question, but my takeaway points for everybody is, in dispute resolution, one size does not fit all. So when we devise procedures and when we practice in particular, we often tend to focus on the elite disputes, on big values in dispute, on cases where the underlying economic incentives are such that you can go all the way to a judge or to international arbitration. And there you also can afford this ideal level of due process. Now, there's a galaxy of smaller disputes that are worth sometimes tens or hundreds of euros, where all of the available procedures are simply not viable. And I think that's what Federico is targeting with this idea, right? So if we transpose that to the specific field of of eSports, is this jury system which is not based on legal expertise, suitable to decide a very expensive, very valuable dispute concerning, for example, licensing of a game for an international World Cup of a certain video game? Probably not, but those are cases that can be dealt with, for example, a viable modern online arbitration that leads to an award enforceable under the New York Convention. However, in such a nascent new ecosystem like esports, we also have probably a lot of amateur disputes that are not viable for that type of arbitration. And that's where I think we could live with a lower level of, traditionally conceptualized due process. Not only in esports, but in sports in general. I used to go see my friends play football in amateur contexts, and dispute resolution there, if you left the field with all of your bones in one piece, you were happy. So something like that is a significant step in the right direction, I think. Mindful of the fact that it cannot be used for everything, of course. One size will never fit all in dispute resolution.
Yes, I do agree, definitely. So, Geoffrey Bruno, given that we don't have a body of substantive law yet in esports, do you think that it would be better to resolve disputes in this field before state courts or with an ODR? And what kind of ODR would you suggest? We heard different models today, so what would be your preference?
I think we have to distinguish between different kind of disputes. As you can see, Federico, there's disputes which need to be resolved very, very fast. And for that kind of dispute, I think your system is good. But when there's commercial disputes, remuneration disputes, prize money disputes, an alternative resolution mode is also good. Why not a court, a judge court? Once time again, I don't know. I don't know, because I think the main problem is the definition of e-sport, is the structuration of e-sport. Now we don't know what is the structure. Do we need a federation? Is it a sport? Not. It's not a sport. What is this? And it's the lawyer with the talking without qualification. I don't know what rules we have to apply, and I think it will be more clear when we were able to give a definition to e-sport. For example, in France, we have a definition, video game competition, the definition. And it's not e-sport. It was very clear in France. And when Patrick presented the definition of e-sport in Switzerland, it looks like the same. So someone is telling about video game competition. You e-sport, it's the same but different words. So first of all, we have to qualify, and after we can choose a model of resolution.
So we always come back to the question of qualification. Yes.
I think it's the main problem.
Yes, I think it's the main problem, definitely. So maybe, Patrick, I'm going to ask you an easier question. So Leonid I can't say his name, I'm sorry. Leonid Shmetenko said that we should maybe create centralized dispute resolution body. And I think he suggested that, in particular for settling prize money disputes. So what do you think? Would it be a good idea in this field for disputes arising from violations of legal rules, regulations, and code of conduct? Would it be a good idea to have a centralized body which would rule on all these kinds of disputes? so that we could maybe have more transparency and jurisprudence that we could refer to, or even in this field it would not be such a good idea?
As you know, I'm a bit biased because I come from the sports law field, so we have a centralized court, and Pietro was talking about the chef sauce, and I'm a bit biased because I like the idea of having a chef sauce, taking what we have today in the traditional sports, maybe taking out what is bad and put a great cream of digitalization in it. No, I like the idea of having a centralized thing, because a lot of questions are, even if the games are different, the questions are the same. I'm not sure of everything, for example, having a ban for every game, because this would be maybe a bit too much, but this is all the legal question. But having something that is able to publish a decision, so you know what was already decided. The same idea of having a list of arbitrators who are competent to deal on this question, just like WIPO is doing, because currently, as Madalena said, I'm not sure who the Bahrain eSports Federation nominated in the CAS case they have, but I don't see many people qualified. So having a centralized dispute resolution system, backed or not by publishers, this is another question, but something that is centralized and is able to, for every league, or at least most of the leagues, be able to issue decisions that are complied with, that are coherent as well. For me, it's one of the best solutions, but I understand that some people don't like the chef sauce.
And well, Madalena mentioned something very important. I think that she said that it would be important to know who the arbitrators are. And she's referring clearly to classical arbitration. So what do you think? It's a question to all of you. Do you think that it's very important that we know the names of the arbitrators, who they are, what are their qualifications, or could we think that dispute resolution system with anonymous or pseudonymous arbitrators or jurors could be a good solution? And I think that Federico has an idea
you're
about
looking at me. I mean, I think it depends. I think it depends. As Pietro said, no one fits all. So it depends on what you compare Kleros with. If you compare Kleros with ICC arbitration, of course, I mean, Kleros seems, not comply with the number of ideas we have about arbitration. You have to know who arbitrators are, etc. Now, lots of the disputes that exist in the online world are like invisible to traditional dispute resolution because they happen inside of platforms. Like, for example, when Counter-Strike, Valve, Overwatch system make a decision and bans a cheater, they made a dispute resolution decision in a black box without actually explaining what was the process that was used. And they really affected the rights of the player that was banned because the guy now lost his money, lost his ability to play, whatever, his reputation. So is Kleros better than that? Kleros is better than that. Compare Kleros to dispute resolution in like a social media platform that tomorrow we're going to speak at length. But Twitter or Instagram or they make decisions about content moderation, which could end with a user being demonetized because of allegedly breaking, plagiarizing, whatever. Those people are having a money loss that is being done by a platform in a black box kind of process, and they don't know who the employee of the company was that made the decision. They don't know who the moderator of Facebook expelled them from the... So Kleros is better than that, and I would argue that we would prefer Kleros to those black box systems. But Kleros is not going to replace arbitration for licensing for millions of dollars type of things. Just it's a tool for a type of disputes that is not going to work for others.
Yes, perhaps I can add. I think we've been talking about different type of disputes, So there's room for everybody. I think there's room for all kinds of alternatives, of ideas, and as Federico was just saying, you know, for certain types of disputes, you need something fast, you need something that is very affordable, and this is what we can see now in recent European legislation. If we look at the Digital Services Act, or if we look at the directive on the digital single market, that they refer to out-of-court dispute resolution mechanisms to deal with whatever, for example, a platform decided. So you have first an algorithm that will decide, for example, if someone uploading a content is violating someone else's copyright. So the algorithm will automatically detect that. The algorithm might not be able to analyze the context, so you may need a human to review that, so there might be a human review, and then you have the option to go to an out-of-court dispute resolution mechanism, and you can still even have the chance to go to the courts. So this system of layers, I think, gives the opportunity to different mechanisms for different kind of disputes to be present and to play a role. And I think from our discussion, what for me is quite clear is that we are talking about the big disputes, and there maybe I will agree with Patrick about the chef sauce, and you know, thinking of, okay, we know that this mechanism work, we know that the capable people that are trained in arbitration that will, there are arbitrators that are good and they know, and they will ensure to have an award that is enforceable. So if you're looking for that, you should be able to have that. But if you're also looking for a clearer solution, and especially when Federico was talking about something that is very, I don't know, very time sensitive, that needs to be resolved very quickly. I talked about the example of Palexpo before, and this is something that works because it's fast and it has to be resolved in 24 hours. So there you cannot expect to have a very lengthy decision. You cannot expect to have 100 pages award, but what you need your strategies to get this decision out quickly. So I think, in a nutshell, we could say that there are different options for the different type of disputes, so maybe defining the dispute will help us to determine this mechanism could work for this type of issues, this other one could work for this other type of issues.
Yes, since we started drifting towards tomorrow's topic, I think that the comparison with content moderation on social media is illuminating, because those are disputes that sometimes have actually a very significant economic value and human value for the parties involved. And up until now, in Europe, now it'll change with the Digital Services Act, but still, outside of the European Union, you don't know if that decision was made by a machine or by a human. You definitely don't know the name of that human. You don't know if that human is a moderator outsourced to make a decision in 15 seconds, or a member of the oversight board that's an ex-judge of the European Court of Human Rights. Sometimes you don't know that the measure was taken. Shadow ban is a prevailing practice on many platforms, and that means that all of a sudden you lose your livelihood as a content creator, and the platform won't even acknowledge that they actually deprioritized your profile compared to other profiles. So because there is a huge access to justice gap, I think, in all of those sectors, it is our duty to think, are there new ingredients to add to the sauce? Not to throw away the nice, tasty stuff we always had, but if there's a new spice that gives me a first assessment of the dispute within 30 minutes, and then we can add other dispute resolution mechanisms that are more traditional later on in a matter of 1 week, and then 3 months, and then maybe a year, then we can, in my opinion, enrich this dispute resolution landscape, which is far from perfect at the moment.
Yes, definitely. You are right. Does any of you know cases when in eSports there are some automatic decisions taken by algorithm? Are there already cases like that? I don't know, but maybe there are.
In esports, I'm not sure, but for example, in social media, most of spam removing decisions are just automated. What we think is going to happen, there's going to be like a division in different, like 3 main segments. For the most objective and simpler types of disputes, AI will be used it's more efficient, it's better, faster. Then for still smaller claims, but slightly more complex because of the need of understanding the context or interpretation, Kleros or decentralized justice systems. And then for more complex disputes involving more higher value or where you need legal interpretation, that's where still, it's going to work like current arbitration, more or less.
Well, during a game, could we imagine that an algorithm would take a decision, automatic decision, because someone is cheating or something like that?
You already have some things like, I don't know specifically in tournaments, but if you play a ranked match in one of the games, usually there are some programs who are going to check if you use some wall hacks or some mods you're not allowed to use. The most clear case are also the cases where you use bad words in the chat or things like that. You're going to have a kind of an automatic ban for at least some point. So some point. But for other stuff, yes. In tournaments, I don't know to which extent they have an automatic decision. But currently, in ranked match in some games, yes, you have some programs in place.
I think it will be interesting to see how AI evolves, right, in this area also. So maybe next year we can have a conference on AI and eSports.
Also, I mean,
yes.
what we see is that even in cases where AI resolves a dispute, there still needs to be like a potential review process made by humans to overturn the AI decision. So that's likely to happen.
Yes, that's a requirement from the EU. But yeah, we'll see. Pietro?
Yeah, no, I have a question I'm very naive because I don't play FIFA or any soccer sports, but there's a referee there, right? So there's a form of AI that makes a call if something is a penalty or is not a penalty. And how it does it is proprietary information of the developer, of course, so it's not something we have transparency about. Couldn't there be a dispute about that?
Just a personal case. With algorithm, I was playing Rocket League, and I stopped to play. I let the car here 30 seconds. I've been banned for 10 minutes automatically. It's bad. But that's why the DSA exists today. You say the shadow ban. There's a rule which obliges the editors to notify the ban. Yeah, it's a very good rule. Yeah.
You didn't have any recourse against the ban? No time for the recourse, maybe.
No time. 10 minutes. It was too fast.
Just a time for a coffee, and then you were
exactly.
And to answer your question, Pietro, I would say it's just like in traditional sport. You don't have any recourse against what the referee says because you cannot. So probably that's exactly what they are going to do in EAFC or FIFA. You cannot say anything on what the referee said on the field of play. It's the traditional rule of no appeal of a field of play decision.
I mean, but the VAR kind of goes in that direction, right?
In tennis, you can call, right?
In the end, the referee decides.
You have a few, yeah, but you can.
It's still a field of play decision in which you cannot appeal. Same as the teammates cannot say, please go see the VAR. It's not their decision. You cannot appeal the referee's decision. It's the traditional rule that is applied in traditional sports. I think that's also a good a good component of the sauce that should be taken in the e-sport. It's a human decision, yeah.
Okay, does anyone in the audience wants to ask a question, share his or her experience, or online? Do we have any question online? Question here? Do we have something online? Okay, so first the question in the audience and then online.
A question to Leandro and Federico. Leandro, you talked about on-call, basically on-call arbitrators, or there my question is, are these just like employees of WIPO that are just there in the office, or how are they on call? How are they remunerated for? How do you ensure that there's always someone that can act within like 5 minutes to make a decision?
Thank you for the question. Yeah, so what we do is this is a case of the trade fairs, right? The one that I was explaining. So it's for a specific event. So let's say the trade fair lasts for 2 weeks. So we have selected a group of experts. In this case, it's happening in Geneva, so there's Swiss lawyers have expertise in Geneva law, and they also have expertise in IP law. So you have like trademark copyright lawyers. There's a panel, and there's a chairman. So whenever a dispute is filed, then the chairman will propose some of these candidates. They will have to also do a quick review on independence and impartiality. But they're external lawyers, so lawyers that are practicing in private practice, that become part of the list of experts for that particular event. So every year we have a quite similar list. There might be a few more, a few less, and they ensure that they will be available, or they indicate their schedule when they will be available, and that's all in the database. So whenever a dispute comes, then you can quickly say, okay, this is a trademark case. We have these trademark lawyers in the panel, so let's try to appoint one of these experts for that particular case. So that's how the system works.
I understand the system for the specific event, but my question was more like, if you want to provide the same service like 365 days a year for the global eSports disputes market, how are you going to?
Well, I think it's a bit ambitious to have like a system that is ongoing 365, let's say, and you have people available to issue a decision in 24 hours. But normally what happens in the cases is we receive the case, and then immediately we will be contacting candidates that meet the requirements. So the parties will indicate if it's an IT dispute and it's under, I don't know, English law, and the case will be in English, so you know in the database exactly which are the candidates that may be proposed. So you do a preliminary inquiry with them very quickly as soon as you get the case. But these are for the traditional mediation arbitration cases that won't be resolved immediately. In the case of eSports, we should, I think, differentiate whether it will be for a specific competition or if it will be more for the, let's say, ongoing activity for any kind of activity. Otherwise, I think it will be a bit difficult to have, decisions that are issued so quickly and 365. So normally, that's how it.
I mean, if you want something like that, you can call me, because
that was my follow-up question. Is like, how do you provide? If there is like a Counter-Strike tournament happening somewhere in Ouagadougou, and they have got an issue, like how do you ensure that there are enough jurors around right in that moment to decide on the case?
So that's one thing I think that we need to clarify, that these are consensual procedures, so you cannot force anyone to participate. In order to do that, let's say there is a competition and you register for the competition, then in the terms and conditions of the competition, there should be a reference that you accept to participate in any of dispute resolution system.
So the players are the jurors?
Yes,
at the same time.
The players will be the ones saying, I accept to be bound. Then you can have like a panel on standby for that particular competition when you know it's happening. If it's a normal competition that there is no indication, let's say no clause, then you cannot force anyone to participate. Both parties in the dispute should accept to go to. So then it's less likely that they will end up in a system like this. So what you need is to tie them somehow, and for that you need to have, for example, in the terms and conditions, specific references to I accept to be bound by, I don't know, a WIPO expert determination, for example, and that's the case. Otherwise, we cannot take the case, right? So we need, or we can take the case from one party and see if the other one wants to join, but you cannot force them. It's not like in court that you go to the court with jurisdiction, you start the case, and if the other party does not participate, well, it will be in default, and still the judgment will be applicable. In this case, for being a consensual system, you need everybody to be on board. That's I think, the difference. Right?
Yes, it's an opt-in system, so you have to choose to be judged like this. What you were suggesting is a very good point. I think you were thinking of the point that the jurors or the persons who are going to take any decision would be the players. That was your point, I think, or maybe you just suggested it. And
what I was imagining is that if you have
because it's very important that the community
so
participates.
if you do have a game of Counter-Strike somewhere, you know, that, and you have 40 participants, that all of them basically are also jurors if there are suspicions of cheating, and because then you have people there that have been in the game, and then maybe the conglomerate of them would arrive at a decision, a majority decision, and then if the culprit would then appeal, then you maybe break it out to like the higher instance, or how do you provide these dispute resolutions?
So there is like a court called Counter-Strike Dispute Resolution that receives uniquely only cases coming from disputes, cheating disputes coming from Counter-Strike. And on that court, there are a bunch of people who are Counter-Strike dispute resolution experts, let's call them, that they are like all the time trying to resolve disputes because they make money for each dispute that they resolve correctly. They have some reward. So there is like a Counter-Strike game, Christmas, some, you know, and, you know, there is a dispute and this goes to that court automatically because players opt in to that when they accepted to play the game. And then this goes to, this court, and the court draws jurors for the case, maybe 3, 5, or the number can change. And then, and these people, well, they get a notification, hey, you have been chosen for the case in the Counter-Strike. Go to the case, you click there, you get the video, you see, okay, the people say that there was a cheating by this player. You have to see, you have to make the decision, you vote on your phone or your computer, and then when all of the people voted, you know, there is a decision made by the majority, and then the reward, the money is distributed to those who voted coherently or incoherently, and it's non-stop, 24/7. It's like Bitcoin. I mean, you can send money at any time, New Year, you know, Christmas, whatever. There's always people like on duty to be jurors, voluntarily because they make money by being jurors. And if there are games going on that send cases to that court, the system will work without stopping at any moment.
How much money do they make?
I mean, that depends. So for now, all of this game is an idea we have to develop, but so we don't know exactly what will be the parameters to use. Parameters, I mean, how much to pay juror per case. We calculate that by, how much effort is required to solve one of the cases. In the Overwatch system, it was like 10 minutes, I think they spent like something like that. How much these people make per hour, so to calculate what is the amount of money they would be willing to receive for working that time. In many cases, these are going to be other players. Or some of them are going to be like even players who also study law because they are interested in understanding it. So it's not going to be very expensive. I can give you some estimates of disputes being solved by Kleros in consumer disputes for like fintech, that people have to decide the cases regarding a customer claiming that a credit card charged them for something they didn't want to buy, some like mistakes. It typically costs like a few $dozen per case, and this is going to go down as there are more cases because this is going to be there is going to be more juror supply, so this will take the cost down. It's really very cheap. It competes not with traditional arbitration; it competes more with AI, if you want. What is the cost of Kleros decision versus an AI decision? And the thing is that AI doesn't tell you why they make a decision. Jurors in Kleros, they do give you a justification. So users really want to see, parties, the losing party wants to see why they lost. And that's a very big advantage that Kleros has over AI, but both work 24/7 and both can do it very cheap, right?
I'm sorry, but we are running out of time.
We can speak later.
You can talk together. So we have one last question that we are going to take because it's very interesting about CAS, the role of CAS in this eSport dispute resolution. And that's a main question, I think. What could be the role of the CAS in this field? Is it going to be a role or no role at all? And maybe I could ask Leonid Shmatenko to give some insights, quick answer on this point. What do you think the CAS could play like a role? The person asking the question suggested that it would be maybe an appellate court. I'm not sure it would be the best idea, but maybe.
We have preliminarily inquired the CAS, whose official statement was more or less, our rules are perfect for any dispute. We do not think, and my colleagues might correct me if I'm wrong, that this might serve as an appellate court. And given the recent jurisdiction of the European Court of Justice regarding the monopoly, we would also think that any arbitral tribunal or any permanent arbitral tribunal for esports would give the parties at least the choice for the seat of the arbitration, so as to to avoid any jurisdiction of the ECJ contravening this. And if there will be any appeal, that would be as a normal arbitral proceedings, allowing to go with the New York Convention or the Lex Arbitra to the courts and annul the award according to the domestic laws, be it in Germany, Switzerland, or somewhere else in the world.
Yes, Patrick, would you like
if
to
I
add
may
something?
quickly just to clarify 2 points, it's that yes, if you look at the CAS code, the CAS could technically work in 2 ways. It can work as an ordinary, what is called the ordinary procedure, which means there is no decision beforehand and you just go there to ask them to issue a decision for your dispute. It can be a commercial dispute. We were speaking before about Twitch, etc. But nowadays, CAS already does that with some federation who give the rights to some TV or some TV channel, and then they have a commercial dispute. It goes to the CAS. Then the other procedure they have is the appeal procedure. You have a decision given by a federation, by someone, whether tournament, whatever, and then you appeal this decision and it gives you an award. But in both cases, you have an award, and in both cases, you can go then to the Swiss Federal Supreme Court. Then I like the idea of the problem with esports is, should it be in Switzerland or not? Should you be able to choose the seat? Given the problem with the European Court of Justice, the idea of having a dispute resolution system centralized for esports, which is not the CAS but works kind of the same way, and where you can choose the seat, is a good idea. And we also talk a lot about the fact that we need a speedy procedure, we need a decision rather quickly, but the CAS already does that as well. I had cases where we had a problem with whether the player could pay a match. We issued the appeal on Monday, the respondent issued the answer on Tuesday, we had the hearing on Thursday, and then decision on Friday, and the match was on Saturday. It can already go quickly. It only depends of the people, of the willingness of the people. So yes, it works. Not sure it's perfect and it's the perfect solution for esports. As Madalena said, it's super expensive. Internally, we call it the 44 rule because they always ask for 44,000 as an advance of cost, which is too much for esports team. So something cheaper, but it works well for traditional sports. So I understand there is some problems, but there is some good things about the CAS, and we shouldn't throw everything away. Just take the best part and add what has to be added in it. A chef sauce 2.0.
Thank you very much.